Hello, this is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead, start putting your questions in the comments now so that as soon as I'm finished with my update, I can get straight to your questions. Now, right now, the main thing that's in the news regarding immigration is what's happening at the border. But I know everybody is anxiously waiting to see what some of those changes are, and it could give us an idea of, whether it's going to affect a broader population of individuals. So I have some more information. They still haven't released the text of the bill yet, but we have some more information about what could be coming in the bill. There's still a lot of disagreement right now on the Republican side, because if you're watching the news, you'll see that the main action that they'll be taking at the border is to shut down the border if they encounter a certain number of illegal crossings in a day. And so they will shut down the border, meaning that they're not going to process, or they're going to drastically limit the number of immigrants that they're going to process at the ports of entry. That's what it means. Now, a part of this is also they're going to be they're going to make the standards, so they're going to make it a lot harder to get asylum or start your asylum claim at the border. And they are going to end the catch and release. So catch and release is where, those who are encountered at the border, so they cross the border without permission and they're encountered, they are being processed, and many of them, as long as they find that they pass a background check and that they do warrant relief in some way, to at least get a chance to apply for relief, they have been releasing them. However, what they are saying that they're going to do is increase the capacity to now detain immigrants. So when immigrants are coming through the border, they're, within a day or two, they are not going to be necessarily receiving parole, but might be staying in detention for the period of time that it's going to take for their asylum interview to determine whether they do warrant asylum. So that's one alarming aspect of this change, is that they will now start looking at detention again. So detention of immigrants. Now, when they say they're going to shut down the border, what they're saying is they're going to limit. Right now, the number is at 1,400 per day, that they will only process 1,400 possible asylum claims per day. And anything beyond that, they will turn everybody else away at the border. And if someone is caught trying to still cross over, even though, and that this is at the border, they're trying to come in through the border, even though they've shut down the border, then they're going to immediately remove them. And if they're caught doing it twice, then it means that they are going to be banned from entering the United States for 1 year. So there are going to be consequences, even when you're trying to get processed at the border and they're turning you away. Then they are going to now have consequences. Well, this is not law yet. It's not law yet. And right now, the Republican side, it's at a stalemate right now. So they are not accepting the proposal. This is the proposal as both sides have negotiated it, but now the Republican side is saying that they don't want a threshold on 5,000, because they said if 5,000 there are 5,000 illegal crossings in a day, they shut down the border. That's the deal. However, they're saying that the way they're terming this is that it's still, the federal government is still allowing the 5,000 immigrants to be coming in through the border without permission. And so they are not agreeing to go along with this. So what does the possibility of detention look like at this point? So if they're processing you at the border, they put you through a credible, fair interview. And if you pass that, then you will have 90 days to put forth your asylum claim at 90 days. And if you pass that aspect of the process, the consideration process, then they will then release you without the work permit and the possibility to finally pursue asylum. If you enter and you do not pass the initial interview, the credible, fair interview, then they will immediately deport you, remove you from the country. Now, the ones that pass the interview, remember that they're not just going to release you. So you come in, you pass that initial interview, they're going to hold you for up to the 90 days in order for you to bring a case about why you qualify for this. If you succeed after those 90 days, then at that point, they will give you another 90 days, but they'll release you with the possibility of getting your work permit to then bring forth your case for asylum, and where you would be granted asylum and a permanent. So what they're trying to do is they are trying to reduce the processing times to 6 months. They're going to be holding a lot of immigrants in detention while they're going through this 6-month period where they're trying to figure out if they qualify for asylum. uh you know I Reducing it to 6 months, I just think at this point, with millions of applications pending right now and with everything taking long, that will be quite a feat. They will have to add a large amount of additional staff members to process these kinds of applications within the 6-month period. So what does that mean? That means that detention could be much longer than the projected time, because that's what we've been seeing in general in all of across the different types of applications and processes that we've seen. I mean, just to get an immigration court date is taking 2 to 3 years just to get a final immigration court date. So it would be quite a challenge to reduce this process to a total of 6 months. Um, Now, the government would have the ability to shut down the border for up to 270 days, and then they will reopen the border as soon as they see that the number of illegal border crossings are reduced by 70%, 75%. So that is the information I have for you regarding it. So far, I have not seen the text regarding expanded expedited removal yet, but as soon as I see that, I will then let you know what I see there. Now, let me go ahead and answer some questions, and then tomorrow I will come with a topic. So tomorrow I said this. I'm going to be talking about the process of going from the 2-year green card to the 10-year green card. That's where you already got your permanent residence and you are ready to renew it. So what do you do from here? When do you renew it? If you're without your spouse, how do you go about removing the condition to get the 10-year? So join me tomorrow for that. But today, for the remainder of the time, I'm going to be answering some questions. So put your questions in the comments right now. So immigration says my friend's divorce doc is fake because they can't verify it back home. What can she do? So it's going to depend on the country. I mean, there are different ways to verify that a document is true and correct. You may have to get it certified. You may have to get an original document and not a copy. But this is where it's so important to get legal advice, because then your friend would be in a better position to tackle that issue. But there are different ways. If it is indeed an authentic document, then there are so many different ways that you would be able to show that. But we need to know the procedure in that country to be able to figure out what the best document is to present. Nephew's under 21, wants to help him apply for a green card. So you cannot directly apply for the 21-year-old nephew. Had your nephew been under 21 and you petitioned for your sibling and the priority date became current before the child aged out, then that would be the process to get your nephew here. But it's too late. It may be too late here, and it may take too long to get him the status. But if you really want to figure out a solution, just give us a call, schedule an appointment, and we can talk more. Can my green card mom adopt her undocumented grandson in the US? So this is often a complicated subject. Whenever it comes on to adoptions, you want to be very careful about that, because when we're dealing with adoptions, it depends on so many different factors, like the country that the child is from, and how old the child is, because usually under immigration law, if they're going to sponsor and adopt a child, they have to adopt them before the age of 16 and have full 2 years, can show 2 years of full legal and physical custody of the child, in order to then apply for the child to get their documentation. But there may be additional options available, but I need to understand the facts here. So this is where it's very important to just schedule an appointment and let's talk. VAWA has been approved. Can that person file for parents under any circumstances? So green card holders cannot petition for parents. You'd have to first become a U.S. citizen, because remember, there's a difference between a U.S. citizen and a green card holder. So you're a green card holder, then you apply to become a U.S. citizen. U.S. citizens can vote, they can travel outside of the country as long as they want. Those are two additional benefits of being a U.S. citizen. So VAWA, just first of all, VAWA being approved is just deferred action. If your VAWA green card is approved, then you get your 10-year green card, but you can't apply for parents yet. Then you have to apply for citizenship. At the point you do get citizenship, then you can apply for your parents as long as you're age 21 or older. How can I request your services? So the first thing you have to do is schedule an appointment, a consultation where I can evaluate your circumstances and provide you legal advice. And then from there, we can determine what I can help you with and move forward. And that's where I provide you the quote and everything to move forward. What are the requirements for a marriage license in Florida? So I don't advise on that. You can always call a courthouse and they can tell you what their requirements are. If you have a mother and she's filing for a child that's over 21, and so if you have a citizen mother and she's filing for a child that is over 21 and that overstayed, how long would it take? So it's a 5 to 7 year process. And keep in mind, this is where I say don't assume that because your parent is a citizen, you will get the green card while being here. Because if you overstayed, you're over 21, it's very unlikely that you will be able to stay here and get the green card. Unless you're applying for an alternate form of relief like VAWA, and still if you're the cutoff point for VAWA is 24, right, going on 25, but once you reach 25 it's too late. So it's 5 to 7 years, but after that 5 to 7 years they will be telling you that you have to go home to finish all the process. You can't stay here to get it if you've overstayed. Can someone get their green card if they have a petty offense through marriage? Will it be a problem? Always, always, always seek legal advice, especially when there's an offense that has occurred in your background. Because I have seen RFEs for things as simple as traffic tickets. So they will hold up your process just to take an extra look at what exactly you got a ticket for, citation for, even arrested for. The petty offense, no, you say here, petty offense, it seems really minor, right? But sometimes offenses that seem minor under criminal law, so oh, it's just a misdemeanor, it wasn't anything big. Under immigration law, it can be a big deal. So this is where representation is key. So can it affect it? It may affect it. It may not, it may affect it. But this is where it's important for me to look over and understand the facts here to determine what to do, how to move forward here. Um, if I'm a Navy guy, how long after can I start my paperwork? So there's nothing that says you can't start right away. But this is where it's important to get legal advice about, is it advisable for you to start right away, or do you need some time to prepare everything before you move ahead with filing? Okay, so I see my Dominican wife and me being an American born citizen have submitted an IOE citizenship form over 3 years. So uh, ago and have yet to hear back from Homeland Security. So this is where you need to get legal advice, because an IOE citizenship, I'm not sure what that is. So usually the first thing you have to do as a US citizen spouse is to file a petition for your spouse to get permanent residence and not citizenship. So you need to get legal advice to make sure you're doing everything properly. Do you have to be married to your spouse to file VAWA? Yes, you do have to be married. Now, there is one thing to keep in mind here. If you are in a state or even a country that legalizes common law marriage, then there may be a way for you to qualify for VAWA as a common law couple. That means you didn't have a traditional wedding or a ceremony, but based on the amount of time that you live together, you do qualify under the laws of the state or the country as a common law. It does qualify as a common law marriage. So that is one exception to the rule here. Another is, do you have to be, so to in response to, do you have to be married to your spouse to file a VAWA? Another is bigamy. If your spouse married someone else previous to you, then married you, technically your marriage may not be valid in some places. In some places, it might not be valid. The US does not usually recognize two marriages at the same time. And so and you say you didn't know that they were married to someone else and that they were not free to marry you, then VAWA could be an option here as well. Hypothetically speaking, let's say you're over 21 and overstayed and your parent is a citizen that's filing for you. How long would it take before you get through? So 5 to 7 years, but after the 5 to 7 years, you're in for a nasty surprise, because they will tell you cannot stay. You cannot stay here in the US. You'd have to go back to your country to finish out the process there. So this is where I highly urge you to get legal advice. Can green card holders apply for their children over 21? Yes, as long as that child over 21 is unmarried, then you can apply for the green card for them. Do you have to be married to your child's father for 4 years to file a VAWA? One thing I do want to make clear here is that you if it seems like you had a long-standing relationship with the father of your child that mistreated you, probably abused you. And if that's the case, we need to evaluate the facts here, because I have had situations where I've had clients who were in the same situation. They weren't formally married, but they were with this person, had children with them, but were being abused, being used, exploited, forced to do work against their will in the household. And that because of that, they obtained the T status. So that would be the same situation, maybe the same situation here. This is what I have to find out. So even though VAWA may not, VAWA, you wouldn't qualify because you're not legally married, you may qualify for other forms of relief. And then keep in mind, if you call the police on this person because they were abusing you, that could also open up the door for the U visa as well. If I make an appointment, do I get to speak to you? So yes, you can opt to speak with me as the attorney. Do you have to be married to your child's father? So I answered that. How long does it stay to remove the conditions after the 2 years? So it's taking anywhere from 2 years to 4 years. Do you have a contact office in Jamaica for consultations? So the great thing about my service is that I represent clients all over the globe, not only in Jamaica and all around the country in all 50 states. And the way we do that is we do phone and video consultations. So it's very easy for us to work with anybody anywhere. All right, so let me go here. I'm going to answer some questions here. Thanks so much for your patience. I'm just going through all the questions here. So I have advanced parole with married pending I485 and also my asylum pending in USCIS. Any problem with traveling? So get legal advice. Remember, and this is across the board here, I'm not your attorney. I can't give you specific legal advice. And this is definitely a situation where you will need specific legal advice. If you have a pending I-485, but then you filed for asylum, usually what asylum means is you can't go back to your country because you are in fear of threats or violence against you. Uh, However, if you now take that travel document and you travel back to your country with a pending asylum, you have now created a contradiction on the record here. And that may raise questions about a possible fraudulent or frivolous filing of your asylum application. So you really do have to get legal advice and guidance so you're making sure you're approaching everything correctly. My interview was in March 1st. Year, and I'm supposed to get my decision in 2 weeks and still decision pending. So it may be that they're looking into additional information or doing an extra background check. Call them to figure out what's going on. My dad's been a US citizen before I was born. Does that mean I'm a US citizen? It could very well be possible. Now, your dad is a citizen, but there are many factors that we have to consider here before we can confirm whether you are a citizen as well. So seeing, it depends on where was your father at the time that he became a citizen. How many years did he stay? Uh, stay in the U.S. before leaving the U.S., or how many years was he outside of the U.S.? So there are going to be some factors here to determine whether you became a citizen when you were born. I have advanced parole with married. Okay, so I saw that. So do you guys do waivers? Yes, absolutely, we do those. We do have to do them too because some of our clients do have issues where we also have to submit a waiver for them. Um, Do you have to attend a physical interview with the wife after the petition? If they schedule the interview, then it's yes, you will be expected to be there with your spouse. I'm eligible to adjust status on April 12th. Can I send my application before to avoid new USCIS fees? So the date that they receive it is going to be considered the date of filing. So if you are eligible on April 12th, but then you submit it before that date, it could affect, they could make a denial. They could deny your application because you still would have submitted it before the date. But keep in mind, I'm not your attorney. This is where it's very important to get specific legal advice based on what kind of adjustment of status you're submitting and so forth. What's a removal order? So it's basically the same as a deportation order. Okay. So if you're here undocumented with marriage, can you get the green card? If you're married to a US citizen, then it's possible. There are two ways though. One is through adjustment of status where you stay here to get the green card. And one is through consular processing where you ask for forgiveness for the overstay and then go to the interview at the embassy in your country. It's going to depend on the facts here. So this is where it's important to schedule an appointment. What type of questions are asked in naturalization interview on the basis of VAWA? So they usually go through the application, verify your information. They're going to go through a list of eligibility questions just to make sure there's nothing that disqualifies you. You do the English reading and writing test as well. All right. Okay, so I'm gonna hop here to the next few questions and then I'm going to head out for the day. How long does it take for someone with a green card to apply for citizenship? Generally, 5 years. If you're married to a US citizen, then 3 years. I'm in school now. My study would be up in 2025, and I would finish at that time. My student visa would be up when I finish school. Can I get a green card to stay? Going from a student visa to green card? No, there's nothing that allows that. But what happens is sometimes you get recruited by an employer. Afterwards, sometimes, life happens. Maybe you find someone who you fall in love with and then marry them. That can also provide you the green card. So while you're here, if something happens that allows you to get it, then yes, but not just based on being a student. Can I use my stocks and money in the bank during affidavit of support if I'm unemployed during filing of the green card? I'm a U.S. citizen sponsoring F1 visa spouse. Would I need? So yes, assets such as your stocks and savings in the bank could count. But what they have a special formula that they apply to determine whether the savings that you have will make up for the deficient amount in your income. How long after your biometrics you wait to get the interview date? So it's all over the place for the interview, and it depends on what you're applying for to get the interview. Thanks, Barnes. I really appreciate it. So, thank you so much for your education, compassion, and free Q&A. People like you are God's people. Thank you so much. I needed that today. Thanks so much. I appreciate that. And I am going to work to get back here at around lunchtime to do this again. So please save your questions. If I didn't get to it today, please save your questions so I can get to them tomorrow. Have a great day, everyone, and take care.